Coming up on this episode of the IoT Inc. Business Show.
The facts change depending on the case, right? Because like you said, one company might have no screen and another company might have a huge screen. But the standard under the FTC Act, Section 5, remains the same. There, we're looking at deception or unfairness. And so again, for deception, it's did you make the statement and was it false or misleading and was it material to consumers?
Lose 5 pounds of belly fat in 5 days. Sound too good to be true? Yeah, it probably is. And because of that, you'd expect the FTC to be all over it. But instead of a weight loss product, what about an IoT product? What's fair? What's deceptive? In this episode of the IoT Show, I speak with Jared Ho about the FTC's role in IoT and some guidance to help your company navigate through the gray.
All this and more on this episode of the IoT Inc. Business Show. The people, the business, and the technology of the next generation internet. This is the IoT Inc. Business Show. And now, here's your host, Bruce Sinclair.
Hello and welcome to the IoT Inc. Business Show. This show is for business leaders and managers employing the Internet of Things for their business or the business of their customers. I'm your host, Bruce Sinclair, and I interview the industry's leading authorities to find out how they use IoT to improve business and create value. If you like this show, subscribe to it on iTunes and go to iotinc.com to check out my complimentary articles, videos, meetups, and webinars.
As an update to my upcoming book, IoT Inc., How Your Company Can Use the Internet of Things to Win in the Outcome Economy. Yeah, I know it's a mouthful. I've always been bemoaning the slowness of traditional publishers. I got my publishing deal in November, and here we are in March of 2017, and I'm just now in the thick of things with editing with them. But I have to admit, having fresh eyes now after all these months is really improving the manuscript. If you want to find out more about my book, you can check out my new website. It's almost ready for prime time. It's brucesinclair.net. You can find out about the book, my workshops, my consulting, and my public speaking. And I'm also producing a few online courses that will be on my website, and you'll find them on LinkedIn. With me today on the IoT Show is Jared Ho. Jared is attorney with the Division of Privacy and Identity Protection at the FTC. He previously served as a policy advisor with the Enforcement Bureau at the FCC and as a Deputy Attorney General for the state of New Jersey, where he led his office's privacy and data security efforts. Jared, welcome to the show.
Hey, thanks for having me, Bruce. I'm really excited for our conversation today.
Yeah, myself included. So has IoT been keeping you busy lately?
Yeah, it's always it's always an effort that our agency is constantly working on. You know better than me, how fast IoT is changing, and the new and different emerging technologies and issues that constantly come up.
Yeah. Now, how much of your work, from a percentage point of view, is on IoT versus? I mean, there was a life before IoT. So how much of your time are you spending on IoT?
I always feel like that's hard to say. Because I work on I work in the privacy and identity protection group, and a lot of the work that we do has to deal with technology. And when we're talking about technologies these days, I mean, what isn't internet connected? So I'd say a fairly large portion of it is IoT related.
Yeah. Well, why don't we dive into it? If you could give us a bit of background on yourself and a background on your work in IoT.
Sure thing. So first off, maybe I can just start by giving your standard disclosure that the views expressed today are purely my own and don't necessarily reflect those of the Federal Trade Commissioner or any of its individual commissioners.
Okay, duly accepted. You are an attorney after all, and so I think that's good. So you state this is that for your own protection or for the agency's protection?
I think possibly Probably for both.
Okay.
We do these on a fairly regular basis, and it's just one of those things that you say.
All right. Well, let's hear about your background. I mean, I'm interested. You obviously have an expertise in IoT. You're highly recommended to me. So, what is your background and what is your work in IoT?
So I'm actually not a technologist by trade. I'm an attorney by trade, and but I have been working on privacy and data security IoT issues. I'd say maybe for the past 9 years or so. First at the Attorney General's office, and then my first job here at the FTC was actually an attorney in our Office of our Office of Technology Research and Investigations. And in that group, we primarily focused on independent research type work.
Okay. And like you said, the privacy is just naturally taking you to IoT. When did IoT come on your radar and the FTC's radar?
I think that's also a hard thing to answer as well, because it sort of is a natural progression. It's as technology has progressed, we've gone from like the landline telephone to black and white TVs to color TVs to personal computers to internet connected computers, and so I like to think of our work as sort of an evolution that has progressed along with technology. And, I see sort of our work as, standing side by side with the advancements that, are constantly happening.
That makes sense. But what is confusing to me now, I by no means am I an expert, but the FTC's role, from what I understand, has been more along the lines of competition and deceptive advertising. How does that fit with IoT? I mean, they seem almost orthogonal.
I'm not sure about orthogonal, but I would actually probably characterize our IoT work as being in line with or a component of our broader consumer protection mission. When we're talking about deceptive advertising, a lot of people might think of like dietary supplements that people talking about dietary supplements and the efficacy of them. But I mean, those are really statements that are made to consumers. And that's really the core of our mission, is making sure that statements made to consumers, whether it's about the efficacy of a product or the type of information that's being collected about a product, that statement is truthful. And so, I think to maybe look forward and look at what's happening today, it's helpful to sort of look backwards a little bit. And so, our agency has had a long history of consumer protection. It was established over 100 years ago in 1914 when Woodrow Wilson, signed the Federal Trade Commission Act into law. And protecting consumers and competition in the marketplace. That mission has stayed the same as sort of technology has progressed and evolved. I really see the FTC is supporting the pillar of innovation and growth, sort of in a way that, protects consumers.
So so I guess it's the deceptive advertising that kind of got me confused. What you're saying is more protection. And when you were talking about the health supplements, that could be deceptive, right? Lose 30 pounds in 30 days. But when it comes to, and I guess I'm just going to bring up the most recent, for us right now, we're in February 2017. So recently there was the Vizio TV situation. And in that case, it wasn't so much their, or was it? Maybe that's the legal definition of what deceptive is. Is it that they just weren't, is it being deceptive if you don't tell the consumers everything you're going to do? Is that deceptive? The lack of telling them? Is that why it fits in, or just help me understand that?
Okay. So maybe I can give a little bit background about our statute and our authority under the statute, and then maybe I can bring that together with Visio and tie that in.
Okay.
So, under our act, there's a provision called Section 5, and that prohibits unfair or deceptive acts or practices.
Okay.
And so it's not only that, you say something and it's not true and you're liable under the act. You might also be liable under the act if you don't say something and should have said something.
Got it.
Or
okay.
if, what you do causes injury to consumers. So, those are sort of the basic prongs of, our Section 5 authority. But, we have broad jurisdiction, and that basically covers any act or practice in or affecting commerce with certain exceptions like common carrier. So that's sort of where we're coming from. So whenever we look at a case, we're looking, is there a deceptive statement or omission that was made? And or was there an unfair act or practice that caused injury or is likely to cause injury to consumers?
Okay, so the omission is kind of the key term here, then, right? At least in the Visio scenario.
Yeah, so in the Visio scenario, we actually had 2 counts, one for unfairness and the second one for a deceptive omission. Under the unfairness count, so maybe backtracking a little bit, I'm not quite sure how familiar your listeners are with the Visio case itself. But
no, maybe give us maybe just a broad overview.
Yeah. So, Visio is a TV manufacturer, and in 2014 they began manufacturing TVs that continuously tracked what consumers were watching. And they did this on a second-by-second basis using automated content recognition software, or ACR software. And so this software captured information on a certain selection of pixels on the TV screen. And from that sort of selection of pixels on the TV screen, they were able to figure out, what TV show you're watching or what commercial is currently on. And, that information would then be sold to, third parties for, audience measurement or advertising effectiveness or targeted advertising. So that's sort of the background on Visio. So what we said on the unfairness side was that Visio collected sensitive personal information about consumers, like their viewing history, in a manner that they wouldn't have expected. And so that's maybe the unfairness prong.
Okay.
On the deception side, we alleged that, while the company sort of disclosed that their software would enable, offers or suggestions about what you watched, they didn't adequately disclose. And this is the sort of like the omission part, right? They didn't completely disclose, how comprehensively the collection was, or how comprehensively they were sharing that information about consumers, TV viewing practices.
And it's interesting because, and this is it is IoT-ish, because like you said, if you squint your eyes, pretty much everything is. But I can tell you, most of the time I get these disclaimers and they just run on and on my phone. I'm just like flipping up to get to that bottom just to hit I accept, or on the same thing on the computer. It's funny that I guess with a product like a television, the interface to make that agreement isn't there. Like, what is the interface? Because, and this goes to other type of IoT devices that don't have any interface at all. And so these issues, I guess they get pretty tangled up. Like, how do you accept? How would they even present it to you for you to accept? Would you have to sign up on their website? Would you have to mail in something physical? I mean, how could they have gotten around this?
maybe we can sort of talk about this more generally, but I think you are right, though. This is sort of one of the big issues related to, IoT. In my mind, IoT, the IoT data and privacy security issues really aren't really that different from the IoT privacy, the privacy and security issues related to like a mobile phone or a desktop computer. Those are, they're privacy cases or they're, data security cases.
Yeah, right.
I really, but I think you hit the nail on the head. What really makes IoT different is sort of that there's this patchwork of inconsistent interfaces, right? I mean, you could have a smartwatch with a tiny screen or a TV with a huge screen, but maybe a scrolling issue, or you might have a phone app which has a smaller screen as well. And I think all of those problems have to be dealt on a case-by-case basis, right? And so it's hard to say with sort of specificity, this is the rule for all IoT devices.
Because there may not even be a screen at all, right? I'm thinking like infrastructure IoT where you're walking down the street now, or you're walking in front of a retail store or you're walking inside a retail environment. There isn't even an interface. It's maybe tracking you visually or it's tracking you, in a number of different ways, but there isn't always an interface. And so there has to be some sort of consent, and maybe you can speak to this, but we hear a lot about privacy, but privacy really is from a company perspective. So for the folks that are listening right now, they're running businesses or they're, in the middle of an IoT business, and what they're really interested in is the liabilities. And privacy is obviously just one type of liability, but we hear a lot about it, I suppose, because of agencies like the FTC, because you're protecting consumers. In the business environment, it's more contractual. So B2B IoT, there's going to be a contract, and in there's going to be everything. There's going to be a signing, as part of the sale. But is that kind of, I guess it's kind of all gray for me as well, but it seems like in that ether, this is where all the challenges are. It's more on the consumer side, so privacy comes up a little bit more than the other types of risks and liabilities. And it's changing, so there isn't always this interface. And so, on a case-by-case basis, it's difficult, and maybe we'll get to some advice, or we will get to some higher level advice, but how do companies deal with this if it is really on a case-by-case basis?
Well, so the facts change depending on the case, right? Because, like you said, one company might have no screen and, another company might have a huge screen. But, the standard under the FTC Act is Section 5, remains the same. And so there, we're looking at deception or unfairness. And so, again, for deception, it's, did you make a statement? And did that statement, was it false or misleading, and was it material to consumers? The facts change depending on the case, right? Because, like you said, one company might have no screen and, another company might have a huge screen. But, the standard under the FTC Act is Section 5, remains the same. And so there, we're looking at deception or unfairness. And so, again, for deception, it's, did you make a statement? And did that statement, was it false or misleading, and was it material to consumers? If you didn't make a statement, did you, omit a material fact that you should have, explained to consumers? Or, under the unfairness prong, did whatever you did it, injure consumers, in a concrete way?
So in the case of the retail store, perhaps what would be sufficient is a big sign as you walked in. I don't know. Maybe if you're walking down the street, that's a little bit more difficult, right? Just how do you not be deceptive if you don't have their attention or if you don't have a screen? And I guess, is this the gray area that just has to be looked at on a case-by-case basis and just judge reasonably? People just have to use their common sense, or are there any other guidelines that, that people can follow?
Well, so we do have guidance for companies, and so it's not it's not as though they don't have materials to refer to, so that they have to apply that to their specific product. And so one example is we've given guidance in our Internet of Things report that we published in 2015, and that product was that report was the product of a workshop that we held where we gathered academics and industry experts and consumer protection advocates together to sort of discuss these challenging issues of what to do with small or no screens. We've also issued the guidance in the past about mobile disclosures, and we gave recommendations on how to effectively give consumers information when you have limited screen space. And so you can find the IoT report and our mobile disclosures guidance on our website. And if businesses are looking for something more specific, we also have start with security and careful connections guidance, and that's IoT specific guidance, and it's also it gives companies a sense of the lessons that we've learned from our past enforcement cases. And so I really would recommend companies looking into our start with security guidance for tips.
Yeah, no, Jared, that's great, and I'll put those links in the show analysis notes. But I do want to pick up on one of those pieces of guidance, and recently it came to my attention, this concept of data minimization. And maybe you need to clarify that. From when I hear that, though, it's saying, just take what you need and nothing more from a data perspective. But that kind of goes counter to where a lot of value is found in IoT, where the data that you collect for, let's say that you have a television, and let's say that it not only recognizes what channel you're on, but it recognizes whether you're in the room, how many people are watching that show, even who it is. Now, you could just limit that data in a very, very, very minor way to just the people, to just your needs. But that data has value to others. Now, I guess maybe I'm kind of talking myself into an answer here, but is the solution there that, again, you just need that explicit consent from the viewers of the television in this particular example, and then you can collect more of that data? Because you know what I'm saying? It's like there is a lot of value in collecting more data in many, many IoT products, services, infrastructures, environments, than just for their specific terms. So how do you navigate that? Wanting to monetize extra data versus your guidance of saying just minimize that, just collect what you need. Or am I interpreting that properly?
Yeah, no, because I mean, on one hand, I do sort of completely agree with you on sort of the benefits of big data and information. It's extremely valuable to not just companies but consumers as well. I mean, from personal examples, innovation and big data have helped me in so many ways. Like, I'm not quite sure I could navigate in my car driving from one part of town to another without some type of phone app to help me
I know I couldn't
to turn, right? And my parents are getting older, and it gives me extreme comfort to when I'm able to sort of turn on the app and watch a live feed of what's going on, from the vantage point of their front door. That wouldn't be possible without, IoT and big data. And so, duly noted that is sort of like an important thing to make sure that companies have access to the information that they need to, create products for consumers.
Yeah, innovate, right,
to innovate. And you do need that. I think from an enforcement perspective, maybe I can give you like a couple examples of, cases where, companies maybe used certain types of data when they didn't have to. So, one example is Accretive. And so in that, case, we allege that the company used, people's real names and personal information in employee training sessions, and they failed to remove that information from computers after those sessions were over. Or in For You International, we charged that the company gave access to sensitive consumer data to service providers who were developing apps for companies. So in both those cases, the risks could have been avoided had these companies used fictitious information for training and developing type purposes.
Or at least anonymous information, right? I mean, at least anonymizing. I mean, that's a term that's used often, is anonymizing it or just abstracting it in a way that you still get the essence, but not the PII. Is that what we're talking about here?
I think anonymization is, a part of the mix that goes, that certainly goes into it. But your point is also well taken too, that, at the end of the day, it comes down to those, two questions again. Is it deceptive or is it unfair? So is there a statement that was made that isn't completely true, or a fact that should have been stated that would have been material to consumers, or was there injury to consumers in some way?
Now, is everything all forgiven if you are able to get the explicit agreement of the consumer? Now, we're talking consumers, and we're not, and I don't think we'll have time to get into the business side of things, but is everything all good if we get that check mark or we get that signature, the electronic signature for the consumer? Can we do whatever, can companies do whatever they want, or do they still have to think about those two, those two rules that we've been discussing, fairness and just making sure that it's not you're not stating yourself accurately.
Yeah, and this is the best part about being a lawyer, is you can just constantly say, I don't know, it depends, it's case by case. Okay. And part of that is because it depends on how you get that check mark from a consumer. The method you got it plays into it as well, and how prominent the disclosure was to consumers, whether or not they expected the type of collection that was happening. So the example again is like Vizio. So when I go to the store and buy a TV, do I necessarily expect that I bring it home and it's going to gather pixels to figure out which TV show I'm watching?
Probably not, unless it was like plastered on the whole box, and maybe when you on the startup screen it came up, and I guess there's that fine line, and you could argue, for example, the last thing I want to talk about to be respectful for your time is devices that are listening. And I have an Amazon Echo at home, and it comes with an app, so I don't have to worry about doing a check mark on the physical device. It has an app, and you can set settings. But I'm going to tell you, Jared, I mean, that's one of those where I was flipping through pages and pages. It's there. I suppose it's up to me to read it, but is that so there's two issues. Is that good enough? If there's like 20 pages of conditions that you agree to, is that good enough? I mean, or is that realistic that anyone's going to read that on that app for my Amazon, for my Amazon Echo?
I always hate to talk about specific products, but I think more broadly, a lot of our work hinges on what's reasonable and what's reasonable for a consumer, and that varies a lot depending on sort of the sensitivity or the volume of information. It also depends on the size or complexity of the data operations, or the different tools that are available, or sort of impacts on business, right? And so that sort of goes into the reasonable the reasonable standard that we sort of look at from a data security perspective. I think what you're talking about, is can you collect that information? And it really depends on the sensitivity, right? It's one thing if you're talking about, your medical history, to what's the weather. Those are two different types of information, and the prominence of the disclosure really depends on the type of collection that's happening.
Okay, so there's a balance there, you're saying.
Mm-hmm. Yep.
Yeah, and so 20 pages of disclosure might be good enough, even, well, yeah, I mean, I guess this is where the common sense comes in, but I suppose I should have read it. For whatever product that is, I should have read those 20 pages, but is that what's expected of consumers? And I think what you're saying is it depends. And it really, you have to look at it on a case-by-case basis. And I'm just, I guess I just want to leave our listeners with some advice on this. And I'm going to use the example of the home. So in the home, there's a lot of vying for who's going to own the smart home platform. And to own that smart home platform, you attract the developers really sexy UIs and really sexy SDKs, and they would develop. And now it's becoming clear through a variety of different products that the voice, at least today, is what's going to control the home. So let's say that our listeners are saying, all right, well, we want to put a device in the home. It's listening. Now, it's not medical records, although I suppose people could talk about their medical, situation. But using that as an example, a hypothetical example, it's really, really would be really, really valuable to listen. I don't know, maybe not store, but listen at all times, because that's a fantastic type of interface that has been demonstrated by a number of different products. What's the situation there? I mean, from an innovation point of view, listening could be really valuable. It could offer some real value to the consumer, but at the same time, it's definitely a privacy issue. So what's your take on that situation?
I guess my take on it is it's one thing if you bring something into the house and, you set it on your kitchen table and you say, listen to me, then right. In that case, you know absolutely what it's doing. It's listening to you. I think it's another story when you buy a house and, you walk through the front door and all of a sudden the house is listening to you. So I guess my take is that, a part of it depends on sort of the expectation of consumers. And then, the other part is, what type of, notice or consent do you have to gather from consumers? So, in the tabletop example, the notice and consent model is very different than the walking into the house model. Like in the walking into the house model, maybe it might not be expected, so you might need some more robust disclosure.
So again, what you're saying is there's an expectation that it's listening to you. You still need to get that sign off, that check mark from the user, but it's contextual, and I guess this falls back to the it depends line here, but it's contextual, and depending on the product and depending on the situation, it sounds like, all right, well, I mean, I think what we're going to have to leave everyone with is that you have to use common sense. You have to look at what the guidance is that's out there today, and we'll list that on the show analysis notes from the FTC, and it's changing, right? It's evolving, and so really the impetus is going to be on the business people to keep on top of this. So beyond the website and those reports, how do people keep on top of it? And maybe we'll just sort of leave it with that. Is what's your advice for everybody to keep on top as this technology develops and as the government is trying to create frameworks to keep up with it to protect consumers? What's your final advice for the makers of IoT devices and how they should just make sure they're not getting into trouble?
Well, so our agency on a daily basis puts out advice for businesses. We have a business education blog that companies can go to for more information, and you can actually sign up for the newsletter. So that might be terrific source for, businesses to go to stay on top of what's happening in IoT, privacy, and data security.
All right, Jared. Well, thanks for your time. And I wish there were some clearer, crisper answers, but I think, where we are right now, at least at this point in time, I think we're just going to have to make do with common sense and just keeping on top of things as best we can.
Appreciate your time. Thank you, Bruce.
Okay, well, that's episode 77. And any multiple 11 is an excellent number in my books. To get an analysis of this episode, plus the great links that are in this episode, and the transcript if you want to read through it, just go to the analysis notes. Go to my website, iotinc.com/podcast. You'll see all the podcasts. You can find this one where you'll find all that information. If you've been enjoying this podcast, there's a few ways that you can give back. If you have a blog, you can write about it. You can share it on social. Every one of those analysis notes has a place, whether you're on your phone or on your desktop, to leave a tweet or to leave a LinkedIn update, or even to share it with an email. Or you can leave a review on iTunes. This is a great way to let others know that the podcast is worthy. You can leave a rating or a review. A rating just takes a few clicks. In fact, I think it just takes one click, and a review will obviously take a few more moments. And, well, I'm going to leave the donation button on each episode, at least for now. It's been pretty much a fail, but I do have 3 donators to date: Kirk, Innovatips, and Duncan. A big shout out to you. In any case, if you want to leave a donation, you can do so through PayPal. I'm not sure how much longer that will be up there, so when you're listening to this episode, it may in fact not be there. I'm your host, Bruce Sinclair. Thank you for listening. Until next time, may your path to IoT business be a reasonable one.
You have been listening to the IoT Inc. Business Show.